For those of you who may be new or newer, I'm Lori Frick. I'm the Child Protective Services Director. Great to see your faces today. As always, I will continue to scroll through because I do like to associate names and faces as much as I possibly can. Make sure again that your cameras turn on if it's safe to do so. You will get an opportunity at the end to ask questions of Sammy and Kate. So when that time comes, please use the raise your hand because it's much easier to kind of track that and it saves from people talking over the top of each other. So feel free to do that when you have questions at the end of this. But I'm very excited for Sammy Magpie and Kate Roy to be leading this presentation today on reasonable efforts and active efforts. I think it's a really great reminder for some of you and some things to highlight. I appreciate them taking their time. These presentations, they don't just happen overnight. This takes work for folks to put some things together. So I appreciate their time and their effort in getting this put together for all of you. Hope you find it to be helpful. And with that being said, I will hand it over to Sammy or Kate, whoever's going to kind of lead it off.
Thank you, Lori. Alrighty, well, good morning, everyone. My name is Sammy Magpie. I am the ICWA Program Manager here for HHS. And like Lori said, you are here for reasonable versus active efforts. And so I really hope that folks get a lot out of this training. I am going to take some time to allow Kate to introduce herself, and then we have a couple of other folks we'd like to introduce as well. So go ahead, Kate.
Good morning, everyone. I am Kate Roy, Social Worker 6 with the Service Help Desk.
Thank you, Kate. And I do believe we do have Bryn Howard on. We have asked her to join this conversation. Bryn, would you like to introduce yourself?
Sure. Good afternoon. My name is Bryn Howard. I'm an attorney, legal counsel with HHS, and I specifically work with the Division of Family Wellbeing and Protection.
Thank you, Bryn. And I don't see that Tina Meth Farrington is on just yet. I do know that she stated she was going to be a few minutes late. She does have a court hearing she needed to tend to. But we wanted both Tina and Bryn to join our call today, just in the event we have any legality questions at the end of our call. And so we have kindly asked them to join, and they've kindly agreed to do so. So I think we can go ahead and get started. We are going to just go ahead and dive right into reasonable efforts, and I will let Kate take that. Kind of like Lori said, if anybody has any questions, please save those for the end. And yeah, go ahead, Kate.
All right. The concept of reasonable efforts in child welfare originated with the Adoption Assistance and Child Welfare Act of 1980, which sought to strengthen the child welfare system and support the preservation of families. This law requires states to make reasonable efforts to keep families together before placing a child in foster care and to ensure the child can safely return home. The Adoption and Safe Families Act of 1997 revised this standard by emphasizing that although states must still work toward preserving and reunifying families, there are situations in which these efforts are not required due to safety concerns. Under this law, reasonable efforts to keep a child in the home or to return the child there are not mandated if the parent has committed murder or felony assault, previously had parental rights to another child terminated, or subjected the child to aggravated circumstances. In these cases, the child's safety takes precedence over family preservation. Iowa law defines reasonable efforts as the steps taken to preserve and reunify a family before a child enters foster care to prevent the need for removal or to enable the child to safely return home. Some other key components within the Iowa Code section include family-centered services, which make up a substantial part of Iowa's reasonable efforts response system and play key roles in preventing out-of-home placements and supporting reunification when placement has already occurred. Concurrent planning allows workers to pursue reunification while simultaneously preparing for alternative permanency options such as adoption or guardianship. If returning a child home is not appropriate or possible, reasonable efforts then shift toward establishing a timely permanency plan. Above all, the child's health and safety remain the central concern in every decision related to reasonable efforts. When considering the services provided to families, the reasonable efforts mandate is not intended to serve as a menu of options for parents to choose from. Instead, it requires that we offer services that are accessible, timely, and adequate to ensure the child's safety, to help prevent removal when possible, and address the family's underlying needs. Some examples of reasonable efforts might include providing parents with a list of local child care providers so they can inquire about daycare openings, offering a list of service providers for parents to contact to schedule evaluations for ongoing treatment, coordinating transportation and appointments through an MCO provider, offering gas vouchers or bus passes, and in our chemical dependency cases, requesting drug testing and giving parents the address and information for the testing facility. The state's duty to provide reunification services does not require it to locate or create services that are not available. Although reasonable efforts typically center on providing services, they also include ensuring visitation. When a child is removed from their home, HHS must make every reasonable effort to return the child as quickly as possible while still prioritizing the child's best interest. Insufficient family time can hinder parental involvement, disrupt healthy parent-child bonding, delay permanency, and worsen trauma experienced by both children and their parents. Research on children in out-of-home care consistently shows that those who visit their parents frequently are more likely to achieve reunification. Studies also indicate a strong link between regular visitation and improved emotional well-being for both children and parents, regardless of the case outcome. There are occasions when a child's physical or emotional safety cannot be protected even during professionally supervised interactions. In these situations, it may be necessary to temporarily suspend contact while an individual work is completed with the parent or the child to address the behavior or the circumstances that compromise the child's safety. Effective July 1st of 2025, House File 367 requires that visitation continue unless a court determines there is substantial evidence that family interaction, whether supervised or unsupervised, would pose a serious risk of physical harm or emotional harm to the child. If this occurs, CPS staff must request a court order to suspend those interactions, including a finding that reasonable efforts toward reunification are still being made. Interactions must continue until a court order is obtained. Staff should ensure the court is informed of all steps that we've taken to avoid suspending interactions and provide an explanation of why those efforts were not successful. The Service Help Desk previously released guidance that outlines the essential documentation requirements for suspending interactions, as well as some sample language to include in an affidavit when requesting the suspension. I'll be sure to throw that in the chat after I'm done with my portion. As a reminder, a court order is not required to suspend visitation during the 20-day child abuse assessment. When it's appropriate, safety planning may continue to be used to suspend visitation during the course of that assessment. You can no longer state that a parent's incarceration alone is a reason to deny visitation. In these situations, parents are entitled to maintain contact with their child unless such visitation is deemed unreasonable. When an incarcerated parent requests contact, several factors should be considered, including the child's age, the existing bond between the child and the parent, the nature of the parent's offense, the facility's limitations, the physical distance between the child and the inmate, and consider the length of the parent's sentence. When evaluating visitation with an incarcerated parent, the child's best interest should remain the primary consideration. Additional factors may include guidance from the child's therapist, and if in-person visitation is not practical, virtual visits may be a more appropriate alternative. It's also important to consider whether attending visits would require the child to miss school, sports, or any other of their meaningful activities. If visitation with an incarcerated parent is determined not to be in the child's best interest, CPS staff will need to obtain a court order to suspend those interactions. The juvenile court is required to make reasonable efforts findings at 3 key stages in every foster care case: within 60 days after removal, at disposition if the child is removed from the home, and again after a permanent plan is established. These findings essentially indicate whether the department has fulfilled its responsibilities to the family and to the federal government under child welfare requirements. As I mentioned on the previous slide, the juvenile court must issue those reasonable efforts findings at those 3 key stages in foster care cases. When reviewing court orders, CPS staff should expect to see specific statements addressing that remaining in the home is contrary to the child's welfare, that reasonable efforts have been made to prevent removal, that reasonable efforts were made to support reunification, and that reasonable efforts were made to finalize alternative permanency plans. There's also a possible court finding of no reasonable efforts, which basically indicates the department has not fulfilled its responsibilities or provided the necessary services and supports appropriate to the case. These findings have significant consequences for both the department and the state. It may result in the loss of federal funding for some or all of the work on that case. It can also delay permanency or even overturn a termination of parental rights ruling. We discussed in detail the department's obligation to make reasonable efforts to prevent a child's placement outside the home unless, based on certain conditions, those efforts are waived due to aggravated circumstances. Again, the child's health and safety must always remain the top priority in assessing the family and in planning and delivering services. States are not required to make reasonable efforts to keep children in the home when doing so would endanger the child. A court may waive reasonable efforts requirements upon finding aggravated circumstances exist, which can include parental abandonment, a parent's conviction for specific crimes against children, or a prior termination of that parent's rights to other children in Iowa or another state.
Alrighty, thank you, Kate. And so Kate was able to provide us a lot of really valuable information about reasonable efforts. And so now we're going to go ahead and dive into active efforts. And so before we go ahead and get started with that, I wanted to provide some background context for ICWA. And so if we can move on to the next slide, please. And so the Indian Child Welfare Act, also known as ICWA, was enacted in a response to a crisis affecting American Indian and Alaska Native children, families, and tribes. And so with ICWA, it set federal requirements that apply to state child custody proceedings involving an Indian child who is a member of or eligible for membership in a federally recognized tribe. ICWA was enacted to protect the best interest of Indian children and to promote stability and security for Indian tribes and families. Prior to ICWA, approximately 75 to 80% of Native families living on reservations lost at least one child to the foster care system. And so I'd like folks to take that statistic into consideration in terms when we're talking about working with Native families. There's a lot of mistrust with working with child welfare workers and specifically state workers, right? Because of historical context. If you've attended my longer ICWA training before, we've gone over very thoroughly what the historical context looks like. And so just looking at that statistic there, we want to keep that in mind when we're working with our Native families. And during that time era as well, child welfare agencies were not sensitive to cultural differences, which created unwarranted removals. And so ICWA protects the sovereign rights of tribes while also maintaining the child's family and culture. ICWA recognizes the authority of both tribal and state courts to make decisions regarding the welfare, care, custody, and control of Indian children. The Act also provides assistance to Indian tribes in the operation of tribal child and family service programs. And so you might be asking, why do we need to use active efforts? What is the point of using active efforts? And so using active efforts is important because it not only ensures that Native children are protected, their culture and integrity continue to stay intact. Every effort is also exhausted before moving forward with a permanency goal, and also taking into account historical trauma and generational trauma as well. And so per code, active efforts does not mean just an identification of challenges a family faces or providing information or referrals. Active efforts are the affirmative, active, thorough, and timely efforts intended to keep an Indian child with their family. Active efforts must be undertaken to provide remedial services to prevent the removal of an Indian child from their home. While the court will not make active efforts determination until a foster care proceeding, it is recommended that active efforts begin as soon as an investigation into a child abuse or neglect referral occurs and before a decision is made to place a child out of home. Active efforts must also be provided after the child has been removed to keep the family together while working together on reunification. And so with ICWA, some of those requirements requires caseworkers to make several considerations when handling an ICWA case. And so this is going to include providing active efforts to the family, identifying a placement that fits under the ICWA preference provision, notifying the child's tribe and the child's parents of the child custody proceeding, and also working actively to involve the child's tribe and the child's parents in the proceedings. And so some examples, when we're looking at active efforts, intervening only when necessary, workers conducting such an intervention should develop a case plan with assistance from the parents or Indian custodian. So we want to make sure that when we're working on developing case plans, sometimes it can be easy for us as caseworkers to develop a case plan for the family while we're in office. An active effort could be actually taking maybe a blank case plan over to your home visit, maybe inviting the family over to your office if maybe a home visit has already occurred. But let's work on the case plan together and make sure that everybody is in agreement with what's being entered on that case plan. And also making sure that there are some cultural needs that are entered on there. Sometimes there are different substance treatment facilities that might be required for the parent to attend. There are cultural specific substance use facilities located here in the state of Iowa that maybe the family might have preference for. So an active effort could be, developing a case plan together, seeking out necessary family preservation and wraparound services to support the family with the child in the home, except where imminent physical or emotional harm may result. And so, making sure that, when we're setting our clients up for services, are we making sure we're setting them up for success, maybe with transportation, other resources that are within our area? Are we networking, making sure that, we are able to get them to be successful in completing their case plan, and making sure that they're able to have accessible resources. And if at all possible, involving the child in some of their case planning. If they're of age, sometimes they might have a preference on placement, maybe with a particular relative. And so we just want to make sure that we're having those conversations with children as well. We want to also make sure that we're making strength-based evaluations of the family circumstances that also include social and cultural conditions and the child's tribe. We're assisting parents or Indian custodians and children in maintaining ongoing familial relationships. And we also want to make sure that we're monitoring progress and participation in services. And so here is a side-by-side of what reasonable efforts versus active efforts looks like. And so I know a lot of folks, this is a huge question. What exactly does active efforts looks like? And so when you're working an ICWA case, you will see that language specifically be changed from reasonable efforts to active efforts. And so an example of a reasonable efforts may be, it is required to go out and visit the family at least once a month. Sometimes folks will schedule that prior at the last time we had met, right? We'll schedule moving forward to the next month. Sometimes we might be swamped and maybe we want to go ahead and confirm that the parent's going to be there before we actually show up at their home. And so a reasonable effort could be maybe making a phone call to the client, making sure that they're going to confirm their visit before we go out there. But an active effort could be, maybe we'll make that phone call, but we're still going to show up at the home anyways. As we know, we're probably not folks' most favorite person in the world. We are intervening at their most vulnerable time. And so we want to make sure that we're still showing up for them. We're building that trust, we're maintaining that relationship with them. Because as we know, the more trust that we build with the family and that rapport that we have, that we're there to do good for them, we're not really there to do harm, we start building that trust and they're going to be more willing to work with you. Going back to that statistic that we talked about at the beginning, there's a lot of mistrust in the system. So building that relationship at the very beginning, showing up for them, is going to be very important. Another reasonable effort could be setting a client up with services, but really no resources on how they're going to access that resource. And so maybe, within their case plan, we're going to have them get a substance use evaluation. Maybe we want them to be set up with drug testing. Maybe we also want them to get a mental health evaluation. But maybe mom or dad doesn't have a car, they don't have a vehicle. And then also maybe they don't have a phone or access to internet at that time. And so an active effort could be actually transporting that client to their treatment appointments or evaluation appointments, sitting down with them, making those phone calls, maybe providing our work cell to them, right? Trying to help them make those appointments, setting those up. Drug testing. I know that that could be a huge gap in a lot of our services just to get parents to check their numbers regularly. And so one of the things that I did for an active effort was I had a list of my folks, all of my families who were set up for drug testing. I had their numbers on a sticky note on my computer, their drug testing numbers, and I just went ahead and I checked it every morning. Even though we know that it is their responsibility to be checking their drug testing numbers, an active effort was me checking their numbers for them. If their number was called, I was going to still go up to the home or wherever they were and try to get them to come with me so I could transport them to their drug test. Obviously, it's going to be optional if they're going to decide to come with you, but at least that you are making that additional effort to make sure that we're trying to set them up for success in their case. Another reasonable effort could be placing a child out of home. A lot of times when we're doing removal, sometimes the most easiest or thought process when there, aren't immediate relatives that are available is to place a child in foster care. And as we know for historical context, we do not want to place Native children in foster care. That is going to be the last possible option for us. And so an active effort could be possibly, looking for a protective caretaker in the home. A lot of times when we're working with Native families, we're working with multi-generational homes. There's a lot of different family members that could be living under one household. That could be grandparents, aunts, uncles, cousins. And so is there any way that we can maybe run some background checks on some of the older adults or caretakers that are currently in the home, where maybe if there is a possible removal, could we place a child with them? That way we're not necessarily disrupting the child's life. And we're not only removing from the mom and dad, we're removing from all of their external relatives as well that they currently live with. And so, if maybe substance use is an issue with, let's say, hypothetical situation with mom, is there a safety plan that can be set up if we place grandma as the protective caretaker? If mom's going to go ahead and use, let's set up a safety plan so that if mom's going to use, she's going to stay out of the home if she's going to be under the influence, and making sure that grandma can be the protective caretaker, keeping that child safe. So there's a lot of different options for active efforts. Really thinking outside of the box, really getting creative as well. I really want folks to lean on some other folks who are familiar with working with ICWA cases, because there are a lot of out of the box thinking that you can do to make sure that there are more visits happening outside of FCS providers doing some things like that. Documentation is also going to be huge for active efforts. So we want to make sure that we're documenting all placements and efforts to comply with our placement preference provisions, especially if we're looking for placing Native children out of the home. Not only do we want to make sure that we're documenting all of our efforts for placement preferences, but we want to make sure we're documenting absolutely everything when it comes to active efforts. And documentation in our case notes isn't going to just look like, I provided active efforts to the family. We want exactly what did you do as the active effort? Did you provide transportation? Did you use your networking skills to maybe set up a resource that provides transportation for that client already? Do we have additional conversations with the family that can offer them some more resources? And so what was the exact active effort that you did? Make sure we're documenting that, because, when we go to court, if you need to provide the exact date and time and what exactly that active effort was, you already have it documented. And that's going to be great for not only the judge, but it's going to be great for the tribe to know as well. And so I am more than happy to share this in the chat. This is going to be a guide for folks that we provide during our current ICWA training, and it's called the Active Efforts Guide. It looks more of like a checklist. I don't want folks to be, scared of it, because it's not a requirement to do this checklist, but it's more of like a guide that I offer all of you workers, because if you are really not too sure what an active effort is going to look like, you can go ahead and look at this guide to see if you've already done something on this checklist, if you need additional resources or additional thoughts thoughts of what exactly could I do that could be an active effort that I haven't done so already. And so we will provide this. I will drop this in the chat here for folks to take a look at. It is fairly lengthy, so there are a lot of different options that you can choose from for active efforts. And so please let me know if you have any questions, comments, concerns about the active efforts guide, but it is just a resource that we're offering to all of you folks. Okay. And so what I'd like to do is we do have some time here to make this an interactive training. And so I want folks, you may already have worked in ICWA case, you may have ICWA cases all the time. Some folks may have never had an ICWA case before, and some other folks maybe haven't had an ICWA case for maybe 2 to 3 years, right? And so what I'd like for folks is maybe we have a lot of people on the call today. Maybe let's just do one example. If folks can think of an example of an active effort that they've done either in the past or maybe something that they can think of that they could do in the future. And while folks are going ahead and providing that, I would like to provide 2 examples of active efforts that we have used or that I have used in the past. And one of them was we ended up having, I used to be a tribal child welfare worker, and I also used to be a state child welfare worker. So I kind of worked both sides, both state and tribal. And so there are situations where, we had a case where mom had a brand new baby, and unfortunately the baby was born positive for substances. Mom was a habitual offender. She ended up, she was involved quite a bit with a few of her other children. And so she unfortunately had burned a lot of her relative a lot of her relatives who were able to help her. And so what we did, as we know, bonding and attachment is very important early on, especially for a newborn baby. We ended up having to place that child in a native licensed foster home because she had no relatives that were available to take the baby. And so outside of the 2-hour visits that FCS was providing, we wanted to make sure that mom was able to get more visits. And so what we did was we were able to work out with the daycare that the child was attending, to work with the daycare to allow mom to at least rock baby for 30 minutes Monday through Friday, in addition to her 2-hour visits that FCS was providing. Now, you may not think that's possible. A lot of persuasion with the daycare facility, right? We had a lot of conversations with them about it. We talked about supervisions. We made sure safety plans were set up in place, but we wanted to make sure that mom and baby were getting their needs met. And like I said, it's really thinking outside of the box and getting creative. And you may not think that's a possibility, but you never know until you ask. And so really utilizing active efforts, trying to use those thoughts, any thought that you have in your family team meetings, to brainstorm together of what can we do to provide active efforts for this family. So I see a lot of folks entering different things in the chat. And so I don't think we're going to have time to go through absolutely everything together, but I do see quite a bit of providing sweetgrass, indoor sage to family, smudging with the family. Definitely agree that's a cultural aspect when we're working with Native children. Making sure that, that you are working with the tribe there, your partner in your ICWA cases, because they are going to be a huge resource for you, especially when you're wanting to know a little bit more about the cultural events. How can we make sure we're maintaining the child's culture when we're placing them out of the home? I see a lot of vouchers. You could even, transportation doesn't necessarily always fall on the HHS worker, right? We could always work on, can they get a bus pass? Do we have gas vouchers that we could provide? There are just so many different things. That's why, as social workers, it's important that we know our area, we network, we know all of the resources that are provided, because you just never know what agency is out there that has funding to be able to help out in situations like this. And so I want folks to go ahead and take some time to read through the chat, because you might have some great ideas that you might not have thought of before. Some of these ideas are folks who have already done this, or maybe some possible ideas for things that you can do in the future. And so my best suggestion is, take a snapshot. If you have your phones, take a snapshot of the chat, try to gather as many ideas as you can, and maybe have like a little ICWA file on your desktop, on your actual desk, on a billboard. That way you just have it easily accessible to you. Kate, do you have anything that you want to add for this activity?
No, I sure don't. Great suggestions, everyone.
Alrighty. So I believe that leaves the floor open for any Q&A that we may have. My contact information was on the screen and so was Kate's. I am always here to help as a case consultant. If folks are interested in additional ICWA trainings, if folks need, even just asking simple questions of how do I get a hold of a tribe? I'm not able to get in contact with them. I can always try to connect you the best way that I can. And so please always feel free to send me an email. This is my job, is to help all of you folks, especially when we're working ICWA cases. So never hesitate to reach out if you have any questions.